What started as a simple delay ended in a life-changing decision. In a Kansas courtroom, Holly Reynolds walks in 15 minutes late to her own hearing. Her excuse? Road construction, a pilot car. Bad timing. But the judge isn't focused on traffic. He's focused on something far more serious. Reynolds had already been given chances, probation, extended deadlines, even compassion during personal tragedy. But this time, she's accused of failing to report to her probation officer any incarceration eranden. Here's where things take a turn. Instead of fighting the allegation, she waives her right to a hearing and admits the violation. That one decision changes everything, because now, the court doesn't need proof. The violation is established. They describe a pattern, missed check-ins, no contact since November, and what they call absconding. Basically disappearing from supervision. Their recommendation: revoke probation. Send her to prison. The defense pushes back. They argue she's been working, staying out of trouble, trying to rebuild her life. They ask the court for another chance. Then comes the most emotional moment. Reynolds speaks. She talks about loss, her father's death, her partner of 10 years, gone. 5 deaths in a single year. She says she broke down mentally, stopped working, stopped reporting, stopped everything. It's raw. It's human, but in court, emotion isn't enough. The judge responds calmly, but firmly. He acknowledges her pain, but reminds her, probation depends on one key thing: reporting, not disappearing, not checking out. He says help was available, but she never reached out. Then comes the turning point. You're not taking this seriously. And just like that, and keep probation revoked, she is ordered to serve the remaining 20-month prison sentence. As officers prepare to take her away, she makes one last request. Can I have time to say goodbye to my kids? The answer: absolutely not. And in that moment, everything becomes real. No delay, no second chances, no way back. This case shows one powerful truth: probation isn't freedom. It's conditional liberty. And when those conditions are ignored, even with real-life struggles, the system moves forward without you.
In the motion to revoke probation on 4/23 of 24.
All right. Ms. Reynolds, you've been present when your attorney made an announcement on your behalf that you would now intend to waive any formal due process hearing that you'd otherwise be entitled to, and instead stipulate and agree that you committed a failing to report violation, which was alleged by Mr. Ketley in his most recent warrant to show cause. In waiving your hearing, you'd be waiving the right to require the state to present evidence and prove the allegation by a preponderance of the evidence. You could challenge the state's evidence with the assistance of your lawyer, Mr. Paul, present your own evidence, and confront the state's witnesses unless good cause was shown. Among other lesser remedies that the court has, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Ms. Reynolds, do you understand these things?
Yes, Your Honor.
Is it your intention to waive a hearing in this case and stipulate and agree that you committed the failing to report violation as alleged?
Yes, Your Honor.
All right. The court finds that the defendant has knowingly waived her right to a hearing in this case and stipulates and agrees that she committed the failing to report violation as alleged by Mr. Ketley. I'll obviously ask for recommendations from counsel, but I want to start off with Mr. Ketley. Mr. Ketley, your allegation was made some time ago. What has been the track record of performance of your client since you filed this warrant to show cause in January?
I don't believe haven't had any contact with her, Your Honor. Since I think the last time she reported me on October 18th, and I set her up for November 1st, and then I haven't heard anything since then.
All right. Thank you, Mr. Ketley. Ms. Gillette, based on what's currently before the court, what are the state's recommendations regarding an appropriate disposition here?
Judge, in this matter, we had a previous violation hearing. She was to have a 60-day sentence or sanction. There was a compassionate release for her, due to her father passing away, allowing her to go to the funeral, which is not usually a thing that always happens. Sometimes we just say you're in trouble, it's too bad, you don't get to go to a funeral, but in this case we allowed that for her. She was to have 60 days done as a sanction last time. Promises to do what she needed to do, promises to go to treatment. And here we are with her basically absconded. So with her absconsion from supervision, she just took off. And with her taking off November 1st, 2023, she didn't report and hasn't reported since. Normally when someone's in trouble, they get right back in and talk to their officer and get into treatment, but instead Ms. Reynolds has not done that. So my recommendations have to be an outright revocation based on her being an absconder and refusing to comply with anything with her ISO. She still had a balance due at the time that we filed the motion to revoke probation.
What is that current balance?
It was $858 at that time.
All right, thank you. Mr. Paul, as defense counsel, what is your recommendation regarding an appropriate disposition here?
Judge, I would ask that the court sanction her and then reinstate her. I know she's been working in Newton. I know that she's been working hard on her sobriety. I believe she would tell the court that, as evidence today, she didn't have a ride. She lives in Newton, Kansas. Judge, I also don't believe that there's been any other criminal matters against Miss Reynolds during this whole time, which is something we rarely see in these cases. Usually when people are not reporting, they're out doing bad things. And from what Miss Reynolds tells me, she's been out doing good things, trying to better herself, work a job, keep that job. And so that's why my recommendation, Your Honor, is to sanction her with what you feel is appropriate and reinstate her.
Very well. Holly Reynolds?
Yes, Your Honor.
At this time, I would address you personally, and I'll ask you, do you have any personal statements that you wish to make to the court in mitigation of punishment here, or anything further that you personally would like to present to the court, in addition to what Mr. Paul has already presented on your behalf?
I'm sorry for being absconded. I didn't become absconded just for no reason. It was just, I had a mental breakdown because my dad died. The guy I was with for 10 years died from kidney failure. It was just so many deaths, one right after the other, that I couldn't handle it anymore. And I mentally broke down, and I quit seeing everybody. I quit going to corrections. I quit going to work. I quit doing everything and got really depressed. It's been really hard on me. I mean, there was 5 deaths all within a year. I mean, it was really bad. And I'm still trying to deal with it, and it's hard.
Okay. Anything else? Okay. I saw the shake of your head no, so I will perceive that you've completed your statement to the court. Ms. Reynolds, you were placed in this case on reporting probation with a heavy emphasis on the word reporting. ISOs often are very aware of community resources that their clients can be referred to when they're having stressful situations. I'm not making light of the pain that's associated with any of the deaths that you referred to in your statement. Everyone has to deal with the tragedy of death at some point in their lives. When you've had a history of any type of drug offenses, it's really important that you stay in contact with your supervising officer, let him know what's going on with you, and then let him make the appropriate referrals or to try to get you some sort of assistance with whatever problems that you're having. What you cannot do is just check out and use that as an excuse to stop your program. What you do in that instance, Ms. Reynolds, is essentially say, I am not a candidate for the reporting probation that the judge wanted me to complete. Rather, what you're essentially doing is saying, I will just face the music of doing my time. That apparently is where we are in this case, Ms. Reynolds. You've had ample opportunity to correct your behaviors, report to your officer, seek his help, if necessary, demand his help, and to utilize the resources that are out in the community to keep you in the community. You've elected not to do that. On top of that, Ms. Reynolds, you're habitually late for court, including being 15 minutes late today. And indeed, there may have been some road construction and a pilot car situation, but you should have left earlier. You should allow extra time. I just don't think you take court seriously, Ms. Reynolds, much less supervision or probation or anything else that was involved in your case. So the only viable alternative is what the prosecutor recommends in this case, and that is an outright revocation of your probation, and that will be the order of the court. The court finds that this defendant has been willfully non-compliant with the terms and conditions of her probation, that it's not in her best interest to be on a probation, which she clearly is not amenable to successfully finish. Holly Reynolds will make promises and not follow through on them. And she's been given ample opportunity and even been punished for previous non-compliance and doesn't even take serious jail sanctions seriously enough to conform her behavior to what's expected by the court. Therefore, the court does order Holly Reynolds to serve the remaining balance of her sentence in Department of Corrections custody. The court orders her to be taken into custody by the representatives of the Greenwood County Sheriff's Office until her custody can be transferred to serve the remaining balance of the 20-month prison sentence that was originally ordered in the case. With that said, Ms. Gillette, I would ask your office to do appropriate research and determine the appropriate number of jail time credit days to which this defendant is entitled and include that in the journal entry of revocation, which will stem from today. I do know she has some jail time credit. I will note that she does have a 12-month post-release supervision period, which this court re-announces. And I believe that she was in a 20% good time credit category with this particular offense of possession of methamphetamine, a level 5 drug felony. All right, with that order made, Ms. Gillette, is there anything further that you need clarification on?
No, I was looking up her jail time credit. And I don't know if she's got any charges out of Saline County, but she did spend an overnight in there in June, so.
All right. I will say that whatever balance exists in this case is declared to be immediately due and payable and collectible. It can be referred to collection agency for further handling.
What if I can pay it?
No additional fees will be imposed today. It does appear that her balance previously was $858, but the court will not add any more bids amounts, despite Mr. Pau's involvement on her behalf and representation. Court finding that I don't think she's got the financial resources while locked up to pay additional amounts. All right, Mr. Pau, are you aware of anything further we need to address today?
No, Your Honor.
Thank you very much for your timely appearance here today, Mr.
Hold on. Can they give you?
Yeah, can I get a week to prepare for this?
She is my
This is
employee.
27 months of my life that's gonna be locked up. I need to say bye to my kids. And
I'm
my
not
job.
understanding a thing you're saying, ma'am.
Can I get at least a week to be able to say goodbye to my kids and my family?
No, absolutely not. Absolutely not.
My employee, sir. And she spent the last 2 months getting her life together, at least for that much,
Like,
to
I
come
really
and work for me.
not
This
getting
court
involved.
disagrees. Getting her life together would have included reporting to her officer. And she didn't even make the effort to do that one time, according to Mr. Ketley. So I'm not sure what your involvement is here, sir, but the court's order stands. She's in custody of the sheriff's office until she can be transferred to the Secretary of Corrections in their custody.
Can you get my affairs together, like at
No.
least 20?
No, I'm not going to defer your time. You need to go into custody today, Ms. Reynolds.
Sir, can you leave, please? Can I give her a hug? Can you leave, please?
That's up to the officer.
You're not going to be cussing in court.
Sorry, sir.
Jill, did you have something else you needed to bring to the attention of the court?
No, Judge, I was just filling out all of the notes that I have to for the journal entry. I've
Right.
started.
Thank you to the officer on scene of being able to take her into custody at this time. If
Well,
there's
Your Honor.
nothing further then, excuse me?
Is yours?
Sorry, did I hear someone?
I was talking to her. I'm sorry, Your Honor. I apologize.
Okay, again, thank you. If there's nothing further than the Holly Reynolds